The Contract Act, Essentials of a Valid Contract. What is a valid contract? Commerce Lecture Online. Essentials of valid contract. There are 10 essential elements of a valid contract. Offer and acceptance, legal obligation, lawful consideration, capacity of parties, free consent, lawful object, in writing and registration, certainty of terms, possibility of performance, not expressly declared void. The first element, offer and acceptance. In agreement, there must be a lawful offer by one party and lawful acceptance of that offer by other party. The term lawful means that the offer and acceptance must satisfy the requirements of Contract Act. For example, A offers to B to sell his cycle for rupees 45,000. This is an offer. If B accepts this offer, there is an acceptance. Legal obligation. The parties to an agreement must create legal obligations. It means that if one party does not fulfill his promise, he shall be liable for breach of contract. For example, A offers to B to sell his home for rupees 2 million. It is a contract as it creates legal obligation. Legal obligation means the parties should fulfill the act which they had committed. Lawful consideration. Consideration means the price. For a valid contract, consideration must be lawful. Consideration is the price paid by one party for the promise of the other party. A contract is enforceable only when both the parties give and are taking something. That something given or taken is called consideration. For example, A promises to sell his car to B for 1 million. For A, the 1 million is consideration, and for Mr. B, car is the consideration. Capacity of parties. An agreement is enforceable by law if it is made by parties who are competent to contract. To competent to contract, it is essential that the parties are of the age of majority, they have their sound mind, and they are not disqualified by law due to any reason. For example, Mr. M, a person of unsound mind, agrees to sell his house to Mr. S for rupees 2 lakh. It is not a valid contract because M do not contain capacity of parties. He is incompetent to contract because he is of unsound mind. Free consent. The consent of both the parties should be free. For a valid contract, it is essential that the consent of parties must be free. Consent is free when it is not obtained by force, undue influence, fraud, misrepresentation, or any kind of mistakes. If the consent of either party is not free, the agreement cannot become a contract. For example, A forced B at gunpoint to enter into a contract to sell the house or to buy the motorbike. Such contract based on gunpoint will not be a valid contract because the consent of one party is obtained by coercion. Lawful object. That means the contract main object should be legal. It is necessary that agreement is made for a lawful object. The object of contract must not be illegal, immoral, opposed to public policy. Every agreement with unlawful object is illegal and therefore contract becomes void. For example, A hires a house to use for gambling. The object of agreement is illegal and the contract is void. Writing and registration. A contract may be oral or in writing. It is preferable that the contract be in writing because it is easy to prove in court. Some contracts must be in writing, like the property sale purchase documents. Those contracts do need registration and they must be in writing. Certainty of terms. The terms and conditions of a contract must be clear, complete, and certain. There shouldn't be any ambiguity or any uncertainty in the time duration or the terms of the contract. If the terms are uncertain, the agreement is void. For example, Mr. A promises to sell 200 books to Mr. B without specifying their titles. If the names of the books are not clear, how could the seller give the books to the buyer? The agreement is void because the terms are not clear. Possibility of performance. A valid contract must be capable of being performed. An agreement to do an impossible act is void. If the act is legally or physically impossible to perform, the agreement cannot be enforced by law. For example, Mr. A agrees with Mr. B to discover a treasure by magic. The agreement is not enforceable by law because it is not possible to perform. Like, share, subscribe for most important topics in upcoming days. Commerce Lecturer Online.